take on the majority of this essay. We have a situation. I outlined, who doesn't like the fact that we're not going to have paper scratch paper? Like, right? That would really, but we have to deal with what they're giving us. What can we do? I'm very curious to hear from all of you, how the digital scratch paper works. Unfortunately, I'm not going to be able to go in to the portal. So please send me a note afterwards, and let me know exactly what. I don't think you're going to be able to take a picture. I don't know if they'll let you. But I really would like to know exactly where it is, if it's left corner, right corner. So please send me feedback. It's open tomorrow, by the way. There will be guidance next week as to, some other things about the scratch paper. But yeah, for whenever you go in or your appointment is, please send me some feedback. So we have February 1st being as the buyer, 400 gallons, and Super as the supplier. February 20th was an express condition, disclaimer. And then 15th it arrived. 20th it's tested. It wasn't good. 23rd there was a notice of defect sent. 25th the buyer covered with a higher price. And then on the 26th there was a rejection of delivery. Bing v Super and Super v Bing are your questions. Okay, so let's start with Super. Bing v Super here. And I'm going to go into the issue spot. Does anyone actually want to take this on? Anyone want to take this essay on? By show of hands? Nope. I don't get to see everyone in here, unfortunately. So use the automated hand raising if you want to take it on. Okay. Fine. Leave it to me. My favorite subject. Yes, it is now. Okay, so we have UCC clearly, right? Under applicable law heading. And I issue spotted this again this morning, so I'm going off of my issue spot here. We have formation. Now, is this a major formation essay? Do we have to go into formation? Yossi, you say no. Why? Let's look at the facts. How do we know if something requires, how do we know if we have to establish the validity of the agreement?
Well, we sort of have to go through the validity of the agreement, but there's
Oh,
definitely
I'm going to correct you. We either do or we don't. So either the essay facts are giving us facts that support formation or they don't.
there's no formation per se because they're going back and forth.
Well, what are we looking for in the facts to know if we, as the applicant, have to go through a full
It would say
formation?
it would say there's a valid written contract,
Yeah, there'd be some type of language as to validity, right?
right?
Do we have that?
No.
No. So do we have to go into formation, like offer, acceptance, consideration? Yeah, we do. Okay. So formation starts with offer here. Okay. Do we have a manifestation to enter into a contract that is communicated? Under the UCC, it must indicate the subject matter and the quantity. Do we have that here? Yes. Easily met there. Okay, so this is not a major issue. Quickly in and out. Is acceptance a major issue, everyone? This is the second time, maybe even third, you're looking at this essay. Major issue here, right? So we have the February 20th acceptance. What happens here? A lot of you got this issue. Acceptance must be unequivocal and communicated. However, what do we have here? What sub issue do we have with acceptance? Blurt it out.
Additional terms?
Beautiful. Who said that? Good job. Okay, everyone got that though, right? Most of the class did get this issue. Most of you started out really strong with this essay. It just kind of fell apart more towards like the warranties and as we got further down into the essay. All right. So what happens with a conditional acceptance in the UCC? It's a rejection and a termination of the offer. It could be a counteroffer, but Bing didn't accept the counteroffer, and thus there's no acceptance. Okay, so the conditional acceptance rule was not met, and therefore, well, the rule of a conditional acceptance thereby makes it not an acceptance. Okay, because anytime you have additional terms in the UCC, it's a rejection and termination of the initial offer. So no acceptance here. Any other sub-acceptance rules that you found in your issue spotting? Have you heard of battle of the forms? Acceptance with different terms? Under the UCC, acceptance does not need to mirror the offer. This is in your outline. For me, it's on page 204. But it's all in the acceptance section, so you can look at it later. But additional terms that are a material change likely to cause hardship or surprise. So material alteration, it alters the available remedies. This was not a major issue. It was in one of the models. So most of you did not hit it. The key was the conditional acceptance. This would have maximized your acceptance section. Okay. What about consideration? So far, we have the offer, but no acceptance. What about consideration? Do we have an exchange of promises? Yes or no? Yes. There was a promise to provide 400 gallons of what, like an epoxy, I think it was called, right? So yes, this is met. Are we going into promissory estoppel? One model had it, one didn't. I don't think you need to go into it. We have consideration met, so we're good. Where do we go from here? Where do we go from here? What do you think? So we have no agreement. So what term is at issue here? What issue?
Is it modification?
It's not modification. First, we're going to, so when the contract fails for lack of acceptance, there's an equitable concept that needs to come in. Quasi-contract. And this is where, so anytime any part of formation fails, okay, especially with offer or acceptance, you must back up the contract with, so let's just say I was once representing two partners and they were in the building industry, and one provided the money for the building of all this property and one took title and was more in line with like dealing with contractors and, you know, was the builder. And they got into a fight and there was a lawsuit with one another, but there was no writing. There was no partnership agreement. But for years, they acted like there was an agreement. So in contract law, when you go into court, which is very unfavored in California, but this is not California specific law, but just know logically or for just informative purposes, as attorneys, we always want to try and establish to the court that regardless of there being a writing, now there was a writing here, right? There was an actual, I think, what, purchase form filled out or something, but there was no acceptance. So because we have a failed acceptance due to conditional acceptance, we have to argue to the court on, well, we have to think, is there an equitable ground here that we can argue that the parties acted in lieu of there not being acceptance, like there still was an agreement? Did their conduct not represent an agreement? Yes, they acted, they appeared. So the conditional acceptance terms will still not become part of the agreement, okay? And we're going to conclude still that quasi-contract will not apply, but we do have to make some sort of argument about their conduct here. And maybe a court based on their conduct implied will imply that there was acceptance to some degree. Ani.
I analyzed the acceptance part differently, so I
Okay.
found there was acceptance. But when I got my feedback back, there was no comment about that, meaning like it was all good. So is it possible that I'm just
Let me take a look at your
if I
essay.
argue it properly, then
Probably not, but let me take a look at your essay and then I'll be able to tell you what I think. Okay?
okay,
Yeah. But if you can send me an email and just say, Shauna, reminder, look at my Feb 16. Okay?
sure.
So I can take
Thank
a
you.
look. All right.
Mhm.
But there was not acceptance here. There was no, because of the conditional acceptance. Okay. Now, if you miss this quasi, it's not going to make or break your essay. This conditional acceptance will. All right. So just keep that in mind. Now, we're out of, and I would have a little heading statute of frauds and just establish quickly that there was a writing. All right. Now we're out of the formation and we think to ourselves, are there any terms? So we're looking for like the perfect tender rule, modification, impracticability, frustration of purpose. Is the perfect tender rule at issue? Yes. And there's no, I mean, some applicants put this in formation. That's incorrect. You discuss it after the formation. Okay. So a seller must deliver perfect goods or buyer can reject. Failure to make a perfect tender is a breach of the contract, and the buyer can reject the goods and cease performance. Here we had a clear breach of the perfect tender rule. Did they reject? Yes, in a reasonable amount of time. It's part of my analysis. Okay, so we have a breach of this rule. And where do we go from here? Are there any other terms that need to be discussed? Is there a frustration of purpose and practicability? Is there any potential modification? Parole evidence rule? Anything like that in the facts? Looking at the facts, we have, this is all the facts regarding formation. These are facts, of course, regarding the breach of warranties, right? So they're kind of going a little out of order. Then we have the receipt of the delivery, and then all the breach and stuff is over here and damages. So next we go into the warranties. There's no other, so warranties is how you show breach in this UCC essay. And you're going to discuss all three. Please make a note. Okay. In a UCC essay, you go into all three warranties if they are at issue. All three. So we have two main ones here. The third one is not at issue. But what are the two main ones at issue? The implied warranty of merchantability. This is breached because it failed to harden properly. And then we have the warranty of a particular purpose. This is breached as well because if you know surfboards, then you know the material used. This is just part of my analysis. You may have, have a kind of a different analysis. That's okay. It doesn't have to be exact to mine. But we have breach of both of these warranties. A lot of you either missed these or only got one, okay? So that's why I'm going to make it a yardstick for the class to discuss all three, even if you're just negating one, okay? And where do we go from here? Damages. What three damages do I say in the approach to always go into? Expectancy, consequential, and reliance. Always, always. A lot of you miss the damages. So that's, again, that disconnect I was talking about not taking the approach literally enough. Damages, defenses can make or break your essay. So think about it. If you miss like 2 out of the 3 damages, you miss a warranty, and you miss the conditional acceptance, there's your 5560. So even if you're getting some other stuff, right, those are major issues. So it's important, you just keep learning from it, keep issue spotting. So we have expectancy damages here. When the seller breaches, the buyer can get the difference between the original contract price and the cover price. So Bing is going to get their expectancy. What about their consequential? This was the most missed damage, by the way. This one. I didn't see it on the majority of essays. It has to be foreseeable at the time of contracting. Lost profits are included. It could be the cost in manufacturing the 50 surfboards and lost profits and not being able to sell them. And then we have reliance. Locating an alternative supplier would be the issue there. All right. Any questions? Second call, Super V Bing. What was the issues here? What was the main? There's one main issue here. Super V Bing. Super has sued Bing for rejecting its replacement shipment and for not paying under the contract. What is Super's main argument going to be?
Their right to cure?
Yes, the seller's right to cure. Exactly. And what are they going to argue?
They would argue that the time given by Bing, it was like 2 days, and they responded in 3, and that's reasonable.
Yeah. So if the buyer rejects in a reasonable amount of time, then the seller can cure by giving reasonable notice of an intent to cure. Did that happen here? What happened?
No, they just let them know.
Well, I think
After
there's going to have to be both arguments, right? So the seller is going to argue what?
That they cured it
We weren't notified in a reasonable amount of time, right?
Right.
We weren't notified in a reasonable amount of time. And then the buyer is going to come back with, yes, it was. Your performance time is up.
Mm.
And you have no right to cure. Do they have a right to cure?
I don't think so.
I don't think so either. 6 days late after the time for performance. Now, here is an area where I do think the analysis kind of could go either way. It's kind of relative. It's not weeks and weeks and weeks. But both models had that, no right to cure. No right to cure. Okay. Hard essay, but hopefully doing this essay and more like them, more UCC essays will allow you, to see the repetition of the issues. And hopefully doing this again gave you more clarity, right, as to what to do here. It's important not to get caught up in any one subject, all right? So when you're going through the subjects,